Uh, Good morning. Uh, नमस्ते, सत श्री अकाल, आदाब अर्ज, जो भी सब किसी को पसंद हो। मैं आप सब लोगों का स्वागत करता हूं इस प्रेस कॉन्फ्रेंस में। This has been a very important election, or let me say it is a very important election because one phase is yet to come. A lot of people have said a lot of things about this election. We will not do that. We will stick to what we have been doing all along, and share information about candidates who are contesting this election or who have contested this election so far for the uh, 6 phases, that for all the 7 phases. Yes, all the 7 phases. Uh, as expected, the number of candidates has increased, as it happens in every election. In this election, it was the number of candidates that we have analyzed is 8337. I am sad to say that 20% of the candidates have declared that criminal cases are pending against them. I am saying because that it is sad, because this percentage of candidates increasing in every election since 2009 is a very sad state. In 2009, 15% candidates had criminal cases pending against them. In 2014, 15 went up to 17. In 2019, 17 went up to 19. And in 2024, 19 has gone up to 20%. Now, this is serious because despite all attempts made by the civil society and by ADR and the National Election Watch, and whatever action the Supreme Court has approved during all these years for the last 25 years, unfortunately, it has had no impact on the political parties who are not expected to be giving tickets to criminal candidates with criminal backgrounds. The Supreme Court has issued instructions, following which the Election Commission has issued instructions in 2020 and then again in 2018, that candidates have to give advertisements in newspapers and all kinds of things. And 2 or 3 political parties were also fined by the Supreme Court for not following their directions. But none of these have had any impact, and the number of criminal candidates being given tickets by political parties continues to increase. As you have seen, it has gone up from 15% in 2009 progressively to 20% in 2024. Similar is the situation with candidates who have declared on oath that there are serious criminal cases pending against them. This was 8% in 2009, went up to 11 in 2014, to 13 in 2019, and now to 14%. So on both these counts, we have to be very, very concerned, very disturbed, and I would say very sad, because Supreme Court has not taken the actions that have been suggested to it, that the kind of action that has taken in the past, way back in 2002 and 2003, when it had agreed and maintained that if there is a lacuna or gap in law, it is the duty of the Supreme Court to fill that lacuna. But now there is a lacuna in law. It has been suggested by the Election Commission repeatedly, not once or twice, but more than 3, 4, 5 times, and by us, that a person who has a serious criminal case against him, in which punishment is 2 years or more of imprisonment, the case has been registered 6 months or a year before the date of the election, and charges have been framed. Those people should be barred from contesting elections. Supreme Court has not had the courage to do this, and I say this with full responsibility. They have made fervent appeals, a lot of emotional appeals to the Parliament, but the Parliament has not listened to the Supreme Court, and Supreme Court has not stepped in to fulfill that to fill that lacuna in law. This is about the totals. Then, if I go into some minor details, I am sorry I am saying in minor details, because 40 candidates have declared themselves that they have cases of murder against them. Now we have people in against whom there are murder charges who are aspiring to become our representatives. Similarly, 173 candidates have charges of attempt to murder, Section 307 of the IPC. 197 candidates have declared themselves that there are charges of crimes against women against them, and they hope to get votes. And political parties expect them to get votes. If we look at the party-wise situation, it is actually not uh, very nice. Nothing can be nice as far as criminalization is concerned. Uh, in this election, 44% of the Congress candidates have criminal cases pending against them. 43% of the BJP have criminal cases pending against them. 13% of the Bahujan Samaj Party and 64% of the CPM. This proportion has also progressively increased. If we look at the Congress from 2019 to 2014, 19, 24, it is 27% to 28% to 39% to 44%. BJP 2009 27%, 2014 33%, 2019 40%, and 2024 43%. BSP 22, 23, 22, 13. This is interesting, possibly because they are contesting less seats. CPM 25, 35, 58, 64. Now, I will confine my observations to the criminalization issue because this is what ADR started with. And I am very sad that this issue, despite of all the data that has been made available to the people, to the political parties, etc., this has had no impact on political parties. The primary onus, although political parties and politicians always say that we give tickets, but people elect such people. I am afraid that is because the voters have no choice. There are in every constituency, there are not more than 2 or 3 candidates who have a reasonable chance of getting elected. And if all those 3 coming from major political parties have criminal cases pending against them, then the voter has no real choice. We also analyze red alert constituencies, and General Verma will give you that number. The political parties have to take responsibility for this state of affairs, which, amongst many other things that have happened in an election, in this particular election, this state of affairs is very sad and worrying. And I will stop here and let General Verma explain the rest of the things to you. And if there are any questions, we'll come back to it at the end after General Verma has finished. Thank you. Over to you, General Verma. Please unmute yourself.
Hello, am I audible?
Yes.
Okay, thank you. Thank you, Professor Chokar. I'll just cover a few other points. Professor Chokar has given the introductory remarks. Firstly, namaskar and good morning to all of you. तो मैं इंग्लिश और हिंदी दोनों में बोलूँगा. सबसे पहले ये बताना चाहूँगा कि ये कंसोलिडेटेड रिपोर्ट है लोकसभा के 7 फेजेस की. 6 फेज तक की रिपोर्ट हम फेज वाइज एक एक कर निकाल चुके हैं और ये कंसोलिडेटेड रिपोर्ट जैसे ही ये अभी ऑनलाइन कॉन्फ्रेंस खत्म होएगी, आफ्टर दिस इट विल बी अवेलेबल ऑन दी myneta.info हमारी जो ADR की वेबसाइट है और जो हमारा myneta ऐप है, दोनों के ऊपर ये अपलोड हो जाएगी जैसे ही ये खत्म होएगी कॉन्फ्रेंस. क्वेश्चन एंड आंसर सेशन हम एंड में रखेंगे. मैं आपको रिपोर्ट की जो समरी है मोटे तौर पे वो बता दूंगा, क्योंकि रिपोर्ट तो तकरीबन 400 पेज की है जिसमें सबसे मोटा बम्प जो है वो क्रिमिनल केसेस के रिकॉर्ड्स का है, लगभग 200 पेज तो वही है। और ओके, सो मैं इस चीज से शुरुआत करूंगा कि जो अभी लोकसभा जो अभी मतलब खत्म होने वाली है, उसमें 43% एमपीज जो हैं वो क्रिमिनल केसेस उनके ऊपर थे, और उसमें से 29% सीरियस क्रिमिनल केसेस वाले थे। There were 88% MPs who were crorepati's, and the average assets of the current Lok Sabha was rupees 20.93. अभी जो आपको इंफोग्राफिक दिखाया जा रहा है, इसमें you can see, I will show it in English and in Hindi. This is a summary analysis of the criminal background, financial and gender details of the candidates who have filed their this thing. So total number of candidates which we have analyzed is 8,337 out of 8,360. जो just hold on, please go back. Let me read the full thing. When I say next, then only go to the next. So the reason of the balance candidates affidavits not being analyzed is that they are not uploaded correctly by the election commission, or they are not scanned properly, or certain pages are illegible. So that is why we are, in spite of our team members trying to ring up the ROs and the concerned officers, till the preparation of the report, we are unable to get clear copies. So then we publish the report minus those many candidates. So as the details have already been covered by Professor Chokar, 20% with criminal cases, 31% crorepati candidates, 14% candidates with serious criminal cases, average assets rupees 6.23 crores. Okay, and ladies, female candidates, 10%. Okay, next, now you can show the Hindi one, please. So just show it, please. Yeah, let people read it. There may be some people may not be able to read English. All right, thank you. Now, coming to the number of parties. As per the, okay, you can take off the infographic. As per the Election Commission website, as on date, there are 2,763 political parties in India. Out of these, 6 are national parties, 57 are state parties, and 2,700 are unrecognized parties. Now, out of this, if you notice, only 751 political parties have participated in the current Lok Sabha elections. This is more than the 677 political parties which contested in 2019, and 464 political parties which contested in 2014, and 368 parties only which contested in 2009. So if you see, 2009 से लेके और 2024 के दौरान जो पॉलिटिकल पार्टीज इलेक्शंस में पार्टिसिपेट कर रही हैं वो दुगनी से ज्यादा हो गई, 104% बढ़ गई। और इसमें एक चीज और जो हमने एनालिसिस में देखा है कि अभी जो ये 8,360 कैंडिडेट्स का हमने एनालिसिस किया है, इसमें से 1,333 नेशनल पार्टीज के कैंडिडेट्स हैं, 532 स्टेट पार्टीज के कैंडिडेट्स, 2,580 रजिस्टर्ड अनरिकॉग्नाइज्ड पार्टीज के हैं, and 3,915 independent candidates. So what is to be noticed is that almost half the candidates are independent candidates. Okay. The other thing which we analyzed was that in the political parties, the percentage of candidates with criminal cases and crorepati's are the highest in state parties, not in national parties, if you compare the national parties and the state parties. So this infographic shows you party-wise criminal cases, which Professor Choker has touched upon. So this is the consolidated thing. On top, you can see Congress 44% with criminal cases, 27 with serious criminal cases. BJP 43% criminal cases and 30% with serious criminal cases. BSP, Baspa with 13% and 10%. CPIM is the highest with 63% and 35%, and independents 14 and 11%. Similarly, party-wise percentage of crorepati candidates, you can see number of candidates niche hai in red, and on top is the percentage. So 92%, that is 403 candidates of BJP are crorepatis. 89% or 292 candidates of Congress are crorepatis. 52% of CPIM, 33% of BSP, and 17% of independents. Now you can show the Hindi infographic. Okay, thank you. Now, I just wanted to also mention that when we analyze the number of candidates with criminal cases state-wise, and the top 5 we took, we found that 3 out of 5 are from Kerala. If you have seen the chart, you would have noticed that the maximum are candidates with criminal cases are from Kerala. And the guy who's number 1 has got some 234 cases against him. His thing runs into 4 or 5 pages of full scat on our report, you will see. It is surprising. That is the state with the highest literacy in our country as to why people with criminal cases are being fielded by the political parties in Kerala. One other thing which I wanted to mention, Professor Choker mentioned the other details, that out of these candidates with criminal cases, there are 98 candidates who have been convicted for offences. मतलब जो जेल काट चुके हैं या उनके ऊपर conviction हो चुका है, 98. He covered murder 40, attempt to murder 173. I also want to mention there are 197 candidates with criminal cases against women, out of which 16 candidates have got rape cases against them. So that is the state of the candidates who are given tickets. Now, if you compare the party-wise crorepatis, I already told you that we have shown you in the infographic. Average assets, again I can tell you, average assets of candidates of BJP are 41.26 crore rupees. Congress is rupees 24.72 crore rupees. Average assets of Baspa is rupees 2.6 crores. And average assets of CPIM is 1.47 crores. The number of women candidates fielded: RJD 29%, BJD 33%, Trinamool 25%, BJP 16%, Congress 13%, and Baspa BSP 8%. So the highest number of candidates fielded by a party is BJD, Biju Janata Dal. Okay. So the other details I will skip because those are all there in the report. Just one small thing I want to, because this report, the second part, or rather in the report itself, details of the recontesting MPs' assets are also there, because that has been taken out from the fresh affidavits which the recontesting MPs have submitted. So there are a total of 324 MPs who are recontesting in these elections. Okay, so you can see in the infographic. So party-wise average assets of recontesting candidates is shown in this infographic. Party-wise is also shown and the overall average is also shown on top. So there is a generally there is an increase always of the recontesting candidates' assets. Out of 324, there are 20 who have shown a decrease. Otherwise, there is an average increase of 43% in their assets. Now, party-wise, if we take the details of recontesting candidates whose assets have increased, BJP is 39.18% increase. Congress is 48.76% increase. Trinamool Congress is TMC is 53.84% increase. JDU is 35.5% increase and DMK is 20% increase. Certain other details, very briefly, I'll cover. The share of wealth among candidates. 5 crore and above, there are 12% candidates. 2 crores to 5 crores, 9% candidates. 50 lakhs to 2 crores, 21% candidates. 10 lakh to 50 lakhs, 26% candidates. And less than 10 lakhs, 32% candidates. If we want to see the chart of state-wise percentage of crorepati candidates, the highest is Meghalaya, 70% candidates, followed by Ladakh, Nagaland, and Mizoram, 67%. Arunachal Pradesh, 64%. Himachal, 62%. And after that is Haryana, 46%. Sikkim, 43%. And amongst the bigger ones, Uttarakhand and Delhi, 42%. Percentage of candidates with crores, I am telling you now. Uttar Pradesh is 40%, Goa 38%, Odisha 38%, Bihar 35%, Assam 35%, Kerala 33%, Rajasthan 32%, Punjab 31%, Karnataka 31%, Manipur and J&K, Madhya Pradesh and Maharashtra, all 30% candidates are crores. Jharkhand 29%, Andhra 28%, Gujarat 26%, Bengal, West Bengal 25%, Chhattisgarh 24%, Tripura 22%, Telangana and Tamil Nadu 21%, Puducherry 20%. Highest assets candidates. The 3 richest candidates contesting the Lok Sabha. Firstly, Dr. Chandrasekhar Pemmasani of Andhra Pradesh, constituency Guntur, party name TDP, movable assets and immovable assets. If I total them, it is 5,705 crores. 5,705 crores. Number 2 is Konda Vishwevara Reddy. He is from Telangana, Chevala constituency. He is from BJP. Total assets 4,568 crores. Third is Pallavi Srinivas Dempo, South Goa, BJP. Total assets 1,361 crores. There are 46 candidates who have declared 0 assets in their affidavits. And there are 767 candidates who have declared assets below 1 lakh. Then candidates with highest liabilities, top 3. First is again Dr. Chandrasekhar Pemmasani. His liabilities are 1,038 crores. Number 2 is S. Jagathra Chakan. Tamil Nadu, constituency Arukkanam, party DMK, liabilities 649 crores. Third is Ramesh Garg, Madhya Pradesh, constituency Morena, Baspa, BSP, liabilities 351 crores. The interesting thing in these number 2 and number 3 is, in case of Mr. Jagatara Chakan, his total assets are 53 crores, but his liabilities, which he has shown, is 649 crores. And in case of the third person, Ramesh Garg of Morena constituency, Baspa, his total assets is shown as 16 crores and his liabilities is 351 crores. Candidates with highest income declared in the ITR, the top three. First is Mr. Naveen Jindal, BJP, constituency Kurukshetra. Source of income, he has shown advisory fee, interest, dividend and pension income. Spouse is also same source. Total income, self plus spouse plus dependent is shown as 84 crores and self income shown as 74 crores. Number 2 is Santrupt Mishra of BJP, Cuttack, State Odisha. Total assets 482. Sources from interest and investment, spouse income, salary. Total income of all, self, spouse, etc. 66 crores and self income also is shown as 66 crores. Number 3 is Venkataramana Gowda Star Chandru, Congress, Mandya constituency, Karnataka. Total assets 622 crores. Source of income, business income, interest and rental, etc. Total income is shown as 55 crores. Self income 16 crores. Other background details. Education. 42% candidates have declared their education qualifications between 5th and 12th standard, whereas 51% candidates have declared qualification of graduation or above. 292 candidates are diploma holders and 217 candidates have declared themselves to be just literate and 121 are illiterate. 14 candidates have not given their educational qualifications. Age details. 32% candidates have declared age between 25 to 40 years. 51% have declared between 41 to 60 years. 17% candidates have declared the age between 61 to 80 years. And 11 candidates have declared their age more than 80 years. So, party-wise gender details, BJP 16% women candidates, Congress 13% women candidates, Baspa 8%, and SP 20% women candidates, Trinamool 25% women candidates, CPIM 13%, RJD 29% candidates women, BJD 33%, YSRCP 16% women candidates, DMK 14% and CPI 7% women candidates. Other parties details you can see in the report. Asset recomparison I have already given in case of. So that is about all from my side. We can now take on questions. Nandini. Okay, so Mr. Radhakrishnan has asked, is it feasible for legislation to be enacted that prohibits an individual with multiple criminal charges, more than one pending against him, from participating in the electoral process? जो ऐसे कैंडिडेट हों जिनके ऊपर मल्टीपल क्रिमिनल चार्जेस हैं, मतलब एक से ज्यादा पेंडिंग हैं, और उनको इलेक्टोरल प्रोसेस में पार्टिसिपेट करने से रोका जा सकता है क्या? सो प्रोफेसर चोकर ने इसके ऊपर टच किया था. यू मे लाइक टू इलैबोरेट सर.
देखिए मिस्टर कनल, दिस इज अ वेरी गुड क्वेश्चन. But my answer to the question is, it is feasible for legislation to be enacted, but it is not going to happen because the parliament will not do that. The reality is that it will not happen. Next question is, if the parliament will not do it, can it be done through the judiciary, through the Supreme Court. It can be done, provided the Supreme Court, I mean, I don't want to say anything about the Supreme Court which may be contemptuous or anything, provided the Supreme Court shows courage to do that. Legally, it is absolutely possible. It is not at all impossible, but the Supreme Court has to show courage to do something which is in the public interest, which the legislature or the parliament are not willing to do. So my answer is, it is feasible, but not possible through parliament, but it is certainly possible through the judiciary if judiciary shows courage. Thank you. इलेक्शन के खर्चे को कैसे कम किया जाए
एंड कैंडिडेट्स को अपने उसके लिमिट के दायरे में कैसा रखा जाए, ये इनके दो सवाल।
देखिए, ये पहली बात तो ये है कि इलेक्शन के खर्चे को कम करने की चिंता किसको है? Who wants to reduce the election expenditure? People who incur this expenditure have never said they want to reduce the expenditure. The candidates and the political parties, every election, they say the limit of expenditure should be increased. So those who incur the expenditure are not interested in decreasing it. It is people like you, Mr. Sajendra Kathat, and me, who want to reduce the expenditure. Now, those who don't want to do it, those who do the expenditure, they don't want to do it. So our role is slightly extraneous, but I agree it should be done. The second question is, how can candidates be kept under the limit? There is no answer to that. The answer to both these things is, if the election commission becomes really serious about it, it can be done. But election commission has not been serious about it. They also so-called maintain shadow registers, etc. But the biggest issue here is, while there is a limit on the expenditure of the candidates, there is no limit on the expenditure of the political parties. So first, the candidates do not observe the limit. 2009 के इलेक्शन में हमने एक एनालिसिस किया था, जिससे ये जाहिर हो गया था that 99% of the candidates spend more than the limit based on their own affidavits. Therefore, this limit is irrelevant. Either there should be a limit on the expenditure of political parties also. So unless that is done, all this discussion of reducing the expenditure and of the candidate is meaningless. So we have to wait for a day when the parliament or the election commission decide that there should be a limit on the expenditure of the political parties. Thank you.
The property and criminal cases have been uploaded on MyNeta. I have checked that before I voted in Pune. Why I conference now and only last phase is to happen? Professor Vinayak Kelkar.
Professor Kelkar, we are doing this because now the data for all 7 phases is available. So we are sharing this data in a press conference when the data for all 7 phases is available. You must have seen the data on MyNeta before you voted for the phase in which you voted. So the data for the 7th phase may have been uploaded a day or two ago. I'm not sure of that. But the press conferences, because data for all 7 phases is now available, and this is to put a finality to this data for the entire election. If you have any objection for us to do this conference, we apologize to you. But we see no problem in doing this.
Next, Nandini.
Once again, Professor Kelkar, it is for the voter to decide whether the voter, she or he, prefers a candidate with more wealth or more criminal cases, or less wealth or less criminal cases. This is under a direction of the Supreme Court of India. We are informing the voters, and we are not telling any voter which candidate to choose and which candidate to reject. We believe that voters should be given as much choice as possible, no, sorry, as much information as possible, so that the voter can make an informed choice. This answer will have to be answered by every voter herself or himself. We cannot answer this question. Thank you.
Next question, Nandu.
चुनाव आयोग ने छठे चरण के मतदान के दिन 5 चरणों में हुए मतदानों में डाले गए मतों की संख्या भी जारी की, और इस बार चुनाव आंकड़ों में जिस तरह से देरी हो रही है और आंकड़ों में परिवर्तन हो रहे हैं, उस बारे में क्या कहेंगे? अदालत ने कहा कि चुनाव आयोग को मतदाता केंद्र के आंकड़े जारी करने के निर्देश नहीं दे सकते। अनिरुद्ध जी, आप तो मीडिया कर्मी हैं, आपको तो इसके बारे में सब पता है। जो भी बातें कोर्ट में हो चुकी हैं, जिनकी चर्चा मीडिया में हो चुकी हैं, हमारा ये मानना था कि चुनाव आयोग को मतदाताओं के पूर्ण सूचना देनी चाहिए और मतदाता केंद्रवार भी जारी करने चाहिए, क्योंकि फॉर्म 17C को पब्लिक करने के लिए हमने सुप्रीम कोर्ट में याचिका दायर की थी, लेकिन सुप्रीम कोर्ट ने उसको नहीं माना, और उसके अगले दिन चुनाव आयोग ने टोटल नंबर वोटर्स के जारी कर दिए। अब ये दोनों बातें बड़ी कंफ्यूजिंग हैं। अगर चुनाव आयोग को टोटल नंबर जारी करने थे तो उन्होंने सुप्रीम कोर्ट की हियरिंग तक क्यों इंतजार की? खैर, उन्होंने जारी किया, उनकी बहुत बहुत धन्यवाद, हम उनके आभारी हैं। लेकिन ये नहीं समझ में आया कि ये 6 फेज के बाद या जब भी उन्होंने जारी किए, उनको पहले क्यों नहीं जारी कर सकते थे? ये बात मेरी समझ में नहीं आई है, और हमारे हिसाब से तो फॉर्म 17C को उन्हें अपनी वेबसाइट पर डालना चाहिए, क्योंकि फॉर्म 17C में ये मतदाता केंद्रवार आंकड़े रहते हैं, और अगर वो आंकड़े जनता के सामने आए तो हमारे ख्याल में जनता को, जो मैंने पहले प्रोफेसर साहब के सवाल के जवाब में कहा था, इन्फॉर्म्ड चॉइस करने में मतदाता को आसानी होगी। इवन वोटिंग के बाद जो दूसरे फेज के मतदाता हैं, उनको भी कुछ समझ में आएगा। तो इस सूचना को 17C वाले को छुपा के रखना हमारे हिसाब से ठीक नहीं है।
Next question.
In many cases, most should the voter vote for the leader. अब ये तो आपने कहा है कि ज्यादातर लोग इस कैटेगरी में या तो वो सबसे खराब उम्मीदवार को वोट दें या नोटा के लिए वोट दें। ये फैसला तो वोटरों को करना है सर। इसमें प्रोफेसर केलकर, आई विल नॉट बी एबल टू से एनीथिंग, इट इज फॉर द वोटर्स टू मेक दैट डिसीजन।
Is there any other question, Nandu?
संतोष सिंह राठौड़, ADR के लगातार प्रति यह संभव हो पाया कि पॉलिटिकल अपने गुनाहित इतिहास के बारे में 3 बार देश के सभी मतदाताओं का आभार व्यक्त करते हैं। देखिए, इसके बारे में हमने सुप्रीम कोर्ट में एक याचिका दायर की थी, जिसमें बहुत सी पार्टियों के बारे में, ये उनके जो प्रिंट और इलेक्ट्रॉनिक मीडिया में इश्तार देने की बात थी, उसका डेटा हमने दिया था कि किस किसने नहीं दिया है या ठीक से नहीं दिया है। तो सुप्रीम कोर्ट ने कहा कि ये इसके लिए आप पहले इलेक्शन कमीशन जाइए। तो हम लोगों ने फिर इलेक्शन कमीशन को चिट्ठी लिखी। वो सारी लंबी सूचना कई 10-20 पन्ने की वो चिट्ठी थी कि आपको हमने ये सुप्रीम कोर्ट को कहा था, सुप्रीम कोर्ट ने आपके पास आने के लिए कहा है, आप इस पे कुछ कार्रवाई कीजिए, जो भी आप मुनासिब समझिए और हमें बताइए। चुनाव आयोग ने हमारी चिट्ठी का जवाब नहीं दिया, उसको एक्नॉलेज भी नहीं किया। उसके करीब 1 महीने के करीब हमने उनको दोबारा से एक रिमाइंडर भेजा है और इरादा यह है कि एक रिमाइंडर और भेजेंगे और अगर वो 2 रिमाइंडर के बाद भी कुछ नहीं कर दिया तो हम दोबारा से सुप्रीम कोर्ट जाएंगे।
Nandini, any other question? We can take one more.
So what is the question, Mr. Shevran? You have said my question is about tainted candidates in Haryana and Ladakh. But what is the question? I don't understand.
Nandini, if he responds, it's fine. Otherwise, is there any other question?
Just a second, sir.
Do you give a similar analysis after about those who have been elected and that those who form government? Yes, we do. We give that analysis only after the election results are available and after the government has been formed. We do that in 2 stages. Why are we seeing rise in candidates with criminal cases? Any specific reasons? Mr. Jain, the reasons perhaps are many. I will not be able to list out all of them. But to me, that all amounts to what I said in the beginning, that political parties give tickets to candidates with criminal cases because they find them winnable candidates. Their winnability factor is very high. As a matter of fact, the Supreme Court in a judgment had said that it had asked political parties to give reasons why they had to give tickets to such candidates. And most of the time, the reason given is winnability. Supreme Court specifically said winnability cannot be a reason. But despite the Supreme Court having said that, several parties continue to give winnability as a reason. Now, what exactly winnability means, political parties will have to explain. I don't understand that very clearly. But the fact is, political parties find criminal candidates or candidates with criminal cases pending against them to be more suitable for whatever they want, which is winning the election. And criminal candidates or candidates with criminal cases pending against them bring all kinds of miscellaneous resources like money, like physical power, like capacity to intimidate, like capacity to fund other candidates of the party, etc., etc. There are many dubious reasons, and I don't think there is any need to elaborate them any further. Why candidates recontesting election? I mean, for the simple reason that they want to be elected again. To me, that is not a mystery. I mean, why candidates recontest an election is the same reason that they contest the election for the first time. I don't think Nota is making candidates recontest the election. Can candidates with murder and crimes against women debarred? Certainly they can be debarred, because somebody had asked me a question earlier whether it can be legislated that candidates with criminal cases not be allowed to contest. And I said it can certainly be legislated provided the parliament wants to do that. So the same is true about candidates with murder and crimes against women. If the parliament wants, it can debar them. And as I also said, parliament will not do it, and judiciary should do it. But as I said earlier, judiciary does not seem to have the courage to do that as of now. So yes, they can be debarred, but unlikely through the parliament, possible through the judiciary, but unlikely to happen. I am sorry to say this. What are my views on the rights of the accused? Well, rights of the accused are absolutely paramount and valid. But the only issue is that framing of charges is not the only essential amendment to regard someone guilty. Certainly not. Framing of charges is the fourth stage in the criminal jurisprudence process, from filing of charges to filing an FIR, three, preparing a charge sheet, and four, framing of charges. Now, the existing situation is that unless somebody is proved guilty, he or she is considered innocent. That is valid. But should that be valid for people who want to become our representatives, particularly when there are more than 4 lakh under trials in the jails whose rights, fundamental rights, are also being violated? They are not being allowed to vote. Their fundamental right to movement is restricted. Their fundamental right to practice profession is restricted. So we can restrict the fundamental rights of 4 lakh people whose charges are much less, who have spent more than their possible conviction time, possible jail time that they would for their offenses. But we will allow people with charges of murder, charges of rape, allow them to contest the election because there are rights of the accused. I believe that people who want to be our representatives and become lawmakers should be held to a higher standard of guilt than normal people. They should not only be good citizens, but they should also appear to be good citizens. And somebody who has 23 charges of murder, etc., and so many others, I don't think they deserve the right to be made a lawmaker. We are not, as I said, the rights of the accused are paramount. But a right of a person who has many criminal cases, the right to become a elected representative of people and to make laws for people, I think that can be restricted and that should be restricted. Thank you. Oh yes, Mr. Pandey, I thoroughly agree with you. Not only should it should not be that 30% vote nota. The requirement should be that if nota gets more votes than any candidate, then there should be a re-election, not re-polling. There should be a re-election in which the candidates who contested the earlier election should not be allowed to contest. This would be the correct way of implementing nota as desired by the Supreme Court. And I must say, while the Election Commission of India has not been willing to do this, two state election commissions, and for those of us who may not be aware of what is a state election commission, under the 73rd and 74th Amendment of the Constitution about elections to panchayat and urban local bodies, every state has a state election commission, which is an independent constitutional body. It does not function under the Election Commission of India. It functions independently as a constitutional authority. They are responsible for conducting elections to panchayats and urban local bodies. Two such state election commissions, Maharashtra and Haryana have issued notifications to the effect that if Nota gets more votes than any physical candidate, then the election will be cancelled and a fresh election will be held. In Haryana, they have said that in the fresh election, candidates who had contested the earlier election will not be allowed to contest. Maharashtra has only said that a fresh election will be held. So these two state election commissions have presented a very progressive example for other state election commissions and also to the Election Commission of India. But despite our efforts, not many other state election commissions and certainly not the Election Commission of India has not yet agreed to do this. We are hoping that with time, Election Commission of India will see the logic of doing so and it will do it. Thank you for asking this question, Mr. Nitish Pandey. ईवीएम सुनवाई पर एडीआर को इन टिप्पणियों से बहुत दुख हुआ है। इससे आगे मैं कुछ नहीं कहूंगा। कोर्ट की अपनी सीमा है, उसको लांघना या न लांघना कोर्ट की जिम्मेवारी है। हम कोर्ट का आदर करते हैं, वो सर्वोच्च न्यायालय है। सिवाय ये कहने के कि एडीआर को इन टिप्पणियों से दुख हुआ है, मैं और कुछ नहीं कह सकता। Sakhi Preet Kaur, thank you very much for this question, and I'm very happy that you as a student have asked this question. How to encourage the Supreme Court is a very difficult question. Supreme Court we can only appeal to the Supreme Court. As a matter of fact, the system requires, if you end up or decide to study law, you will learn that you make a prayer to the Supreme Court. So we pray to the Supreme Court. We cannot encourage the Supreme Court. We pray, we try and persuade, we give them legal arguments and other justifications, but that is all we can do. I don't know what else can we do to encourage the Supreme Court, but I am happy at your question. Thank you for asking it. Katyani, can a case be filed in SCR? Well, a case can be filed only if the candidate has violated the Supreme Court orders in terms of not publicizing his or her criminal cases that he or she has declared in the affidavit. As of now, I don't think of any other provision to this. And free and fair elections and constitutional morality is a very broad term, and the Supreme Court has interpreted it many times. And sometimes they interpret it more strictly, and sometimes they interpret more loosely. So, under specific conditions, it may be possible, but broadly unlikely to succeed. Can EC not follow the Supreme Court on the matter of Nota? Mr. Ravi Thomas, this question can also only be answered by the ECI. We have been trying to persuade them, but they have not yet been amenable to our persuasion. Amita Joseph, has ADR been targeted for this work? I don't know what you mean by targeted, but ADR continues to do what it has been doing, and it proposes to continue to do what it has been doing so far.
There is a question on third gender. To that particular commenter, please write to us at adr@adrindia.org. And sir, now we can wrap up.
Just one thing. One is there are, I think, three transgenders who have contested, but the exact details you can check up in the report when it is uploaded. The second issue is about the question from fourth state person about Ladakh and Haryana. So, Haryana, it is given in the report, 12% candidates with criminal cases, and out of them, 6% with serious criminal cases. And from Ladakh, there are only three candidates. They do not have any criminal cases. I hope that answers your question. Okay, with that, Professor Choka, we can, I think,
Thank
wrap it up.
you. Thank you very much. And we thank everybody who attended this conference. We are grateful. We hope you will give this report wide publicity. Thank you very much.
Thank you, everyone.
We appreciate your visiting our websites adrindia.org and myneta.info and listening to our podcasts and webinars. We appreciate all the support you have given to us. Please continue that support and donate at adrindia.org. Thank you.